Good evening and welcome to this hangout on Equalization Levy, the new levy which has been introduced by the Government of India in this recent budget which was presented in February 2016. And starting today, that is 1st of June, the Equalization Levy has come into effect. This is in response to the OECD's BEPS project, Action Plan 1, which talked about levying tax on the digital economy transactions. There were 4 options that were proposed. Government of India set up a committee in January, February earlier this year to examine these options, look at India-specific issues, and finally the committee recommended levy of equalization levy, and this is what we have finally seen in our Finance Act of 2016. Now that the levy has become operational, to discuss the practical aspects, the business aspects, and the operational issues around the levy, we have a panel of experts today who will discuss with us on different aspects of equalization levy. Let me introduce my panel. We have Rakesh Jariwala. He's a partner with Ernst & Young and based in Mumbai. He's a tax leader for media and entertainment practice. We also have Sandeep Ladda, who's a tax partner with PwC. Sandeep is a leader for India technology and e-commerce sector for PwC. Sandeep, thank you so much. He's joining us from Silicon Valley. It's 4:30 a.m. His time. And we also have Vinay Mangla, Head of Tax from Google India. Thank you so much, gentlemen, for sparing your time. And Rakesh, let me start to you, with my first question. Now that the equalization levy is here, there is no point in debating whether it is just or fair. The levy is here to stay. 6% tax, which an Indian company or an Indian payer has to pay on a B2B transactions. What is it that in interactions with your client you've observed as an impact on the business model? What has been the commercial impact of this 6% levy? Rakesh?
Sure. Thanks, Ameya. So let me step back and say that firstly, what law currently provides is that payer shall deduct and pay. Law does not really fix the obligation or ultimate bearer of the tax, and that I think is going to get determined based on the demand supply equations as well as the contractual obligations that the party may have. So that's going to be open to debate. In terms of clients, again, the clients for us as EY organizations are going to be on both sides of the spectrums. I mean, the advertisers, the agencies, as well as the platforms. So the feedback essentially from the platform perspective is really, is this something that was really needed when India was going through a growth spectrum? Internet boom is expected, and is this really something that India wants to implement at this juncture, and that to take a pioneering effort in implementing such a levy, which is not precedented? And the clients are really exploring whether this is something that can be better implemented now that it is in play. So that's as far as the platforms are concerned, the recipients essentially. As far let's look at from a payer perspective, there are a host of players here. As I said, there are going to be advertisers who are really seeing this as an additional burden on them in addition to service tax, especially the guys who are not able to offset that. They're resisting this levy because it increases the cost of advertising. Let's look at the agencies, advertising agencies. They are actually the ones who are really stuck in the middle, if you look at it, because they have clients on one side to really handle the advertisers, who may say that they probably will not be able to compensate them for an equalization levy that is levied. Equally, the advertising agencies are the people who are going to deal with the platforms on the other side. And equally, if platform also says that they will not be able to bear the burden, then it's the agencies who are really standing in the middle. So there's a lot of confusion, commotion at the moment, and people are trying to debate, negotiate, and fairly discuss as to how this levy can be equitable for all.
Sandeep?
So, to your question around the impact on the industry, it is about $1 billion industry in India, the digital advertising industry. And based on estimates by industry experts, etc., we understand that approximately 40% of this $1 billion industry, which is about 6,500 crores approximately, is attributable to those advertising mechanisms which are adopted, which are internationally through international e-commerce companies. So therefore, what really we are looking at is a 6% collection on that, about 2,500 crore, which comes to about 250 crores. So if we are really looking at such a narrow sum of money to be collected by the government, whereby they are really putting the entire industry, the advertising industry or the e-commerce industry, and through this whole burden of a new tax, it is not inside the Income Tax Act, it is outside the Income Tax Act. And to put through them through a new levy, on one side, the government is talking about unifying all the indirect taxes. Of course, one of the questions is whether this is an income tax or whether this is an indirect tax. That itself is not very clear. So on one side, the government is trying to unify the various indirect taxes. On the other side, newer taxes like these are introduced and are increasing and the cost of doing business in India. So eventually, I do see and that the cost of this entire 6% levy, and we are really talking about the first of such services, because the government has reserved its right to introduce newer services, and there are 12 such more newer services that are likely to be introduced in the near future, and also the possibility of a higher rate, because 6%, based on my discussions with the CBDT in the recent past and also with the Ministry of Finance, is that this is just an introduction by way of 6%, an introduction by way of just one service. So the chance of this getting into a wider set of services getting attracted, and also the rate going exponentially high over a period of time. And on the other side, those companies already paying about 15% service tax, and in the GST regime, when implemented, will be about 18%. Without an appropriate credit mechanism available, is seriously going to hamper the payer side of the economy or the ecosystem, so to say, going forward.
Right. Vinay, let me come to this business aspect of equalization levy. The committee report recommended a rate between 6 to 8%. Is this rate of tax, what we are calling as the equalization levy, compared to the general industry profitability? How does it pan? Is it a moderate rate? Is it on a higher side? What is the perspective that you picked up from your industry peers?
Yeah, so effectively, if one looks at one of the most significant concerns, right, with respect to the levy, apart from that it's taxing a specific industry at a time when this industry has a potential of exponential growth and supporting other industries. Apart from that, I think one of the most significant issues which this levy has is exorbitant high rate of tax, right, which was proposed for 6 to 8%, right. No basis was given that on what basis, on what economic analysis, because look, effectively it's an income tax, not defined as income tax, but the fact is it's a tax on gross income. So it's an income tax which even um, uh, with respect to, if you look at the current regime and how with respect to even with this levy which exempts permanent establishment, it's based on activities performed in India, right? So this assumes that a large part of activities are performed in India, and assuming a 6% assumes a very high percentage of attribution in India, right? Which is what a cause of concern. And I think the bigger concern is that in the beginning this rate has been adopted, right? So starting next year or subsequent years, right? It will be just a rate change, right? So that's, I think, that's the most significant impact on the industry, that this disrupts the business operations, right, and affects the profitability, right, and more importantly, with no credit being available, right, and the fear and to a large extent of double taxation, right, also remains with this levy.
Right. So just one quick question to all three of you, and you can answer in yes or no. Would you have been happier if this would have been a income tax and on which credit was available, or a service tax which was again under reverse charge where the credit is available? Would this form have been a better solution rather than calling it as an equalization levy, not income tax or a not indirect tax? Sandeep,
So,
a brief
so
answer.
yeah, the brief answer would be yes, clearly yes, and I would therefore think that the government should have considered something on these lines.
Vinay?
Yeah, so definitely yes, it would have been much better that it should have been classified. At least the classification would have been made clear that whether it's an income tax or an indirect tax. But the reasons are clear, right? That why this has not been named as income tax is to simply uh, deny treaty relief, right? Or so that the levy does not become subject to the double taxation avoidance agreements, right? So that's it. But yeah, it's definitely, to answer your question, yes, it's definitely better if this gets classified as an income tax or as an indirect tax, right? Whatever it is.
Rakesh, do you agree?
Yeah, yeah, I agree with that.
All right. So just continuing this discussion, Rakesh, on the business impact of this 6%, which Indian entity has to deduct. So clearly, let's look at different situation. B2B is what we are calling at. So an advertisement agency receives the money from the client. That advertisement agency could be in India, could be outside India, and then you have a platform which is eventually receiving the money. Finally, based on your interactions with the client, who's bearing the tax, and what are the commercial negotiations that you've seen in the last few months as to who is eventually bearing the large burden of this? Is it eventually a platform, or is it the advertising agency, or is it the client?
Let me put it this way that we've just got started on this. I don't think there is a let me crudely say a winner as yet as to who's ultimately going to bear the tax or the brunt of it. It's as I'll go back to my opening statement to say it's going to be determined by the demand supply mechanics and how much one person really needs the other, to be very candid on this one. Yes, what may happen in the short term is that while the bigger boys may be able to sort this out amongst themselves on both sides of the spectrum, it is the smaller guys who have limited ability to really fend this off may in the short term be bearing the cost if they are not able to push that through. Equally, let's look at scenarios where the payments are being made through payment gateways. Some of those mechanisms themselves will ensure that if you're making a short payment, then the payment for services will not go through, and in that case, you will not have any option but to really make a gross payment, and thereafter onus automatically falls on the payer really to really reach out independently to the platform to see if they bear it, and then that puts you in a different demand supply dynamic. So to answer your question in brief, I don't think we have winner as yet. The discussions are still going on, and it'll be a while before we end up with an answer.
Sure.
I mean, this is not new. We have seen this on the broadcast and advertisers. This has gone on for some time, and I don't expect any immediate resolution, to be honest.
Sandeep, have you picked up any trends around this point?
Well, I do think that the business models, the way it is currently structured for some of the the larger groups, are likely to get under reconsideration at least. So there could be two or three different types of business models that are currently being employed by different set of e-commerce players and and online players. I do think that there will be discussions around, and I'm hearing already that there are discussions around how can we structure it better. Can we put the burden back on the consumer, because ultimately it's a tax that has to be borne by the consumer. While yes, the demand supply equation will really determine who is ultimately going to bear. It is eventually going to be the person whose need or desire is to continue with that service is going to determine whether
Sure.
the cost can be really passed on to the consumer or not.
Sure. But Sandeep, you mentioned two or three business models. Can you elaborate on any one of the models, how it might undergo a change?
So, for example, there could be, a one business model is where, the foreign e-commerce company is having a subsidiary in India, and that subsidiary in India is currently dealing directly with the consumers in India, and doing the B2C transaction. Uh, so if the payment is going currently from the consumer to the Indian company, right, and which is the Indian company of the foreign company, that Indian company is then making a payment to the foreign company. Now, if the foreign company is powerful enough, and is a big boy, then the foreign company will want to do the business directly with the Indian consumer and pass on the baton to the Indian consumer, right? Because the issue is that if the domestic transaction, which is the current business model, as I explained, is where the Indian consumer is making a payment to the Indian company. In on that transaction, there cannot be any equalization levy. Of course, the pricing mechanism there can change. So the second way in which this can really happen is that the Indian company, which is the subsidiary of the foreign e-commerce company, can she can increase the cost. Say, for example, charge 107 instead of charging 100 originally that was being charged, right?
Right.
And therefore, in that way, recover the extra 6% that is the cost in the ecosystem, and then
Right.
it is making a payment onward to the its parent, or its service provider. That 107 actually is subsuming the cost of the equalization levy. So there are two or three different ways clearly in which companies may be considering going forward, depending again on the demand supply situation.
Right. Vinay, we've seen equalization levy rules which were notified by the government couple of days back. There is a description about how the payment should be made, how the annual tax return should be filed, and we have June 30th as a deadline for filing equalization levy tax return. And then there are few operational aspects that have been notified. As a business person, how easy or difficult it is to do a compliance around equalization levy and also report all the details that the government is asking for in the forms that they notified a couple of days ago.
Right. So if you look at on this digital advertising, right, a lot of small and medium enterprises, right, use this as a across digital platforms being provided by foreign companies, right. So it's a substantial compliance burden which gets increased on them, right, where they'll have to keep track of payments. And remember that a large part of these payments which are being made offshore happens through credit cards and debit cards and all, right? So it's an automatic payout, right? So which then could be possibly, right? Effectively, how do you comply with the equalization levy in such a case? Even if you keeping track of all these transactions and then right submitting annual return, right? So for a smaller players, it's a substantial increase in cost. Yeah, but for the larger players, right, agencies and all, that at least the reporting is not that complex. But yeah, keeping track of all the transactions, especially the transactions which happens not through by way of a check or by way of a credit card payments and all, that becomes difficult to comply.
Right. Any quick comments, Rakesh and then Sandeep, on the new rules that were notified a couple of days back?
I mean, my limited comment here is that they're fairly restricted in terms of what they've outlined. I agree with some of the thoughts that Vinay shared, but I would have expected a more comprehensive set of rules clarifying very many aspects rather than restricting it to a form and certain rules around appeal.
Yeah, so
Sandeep,
I
during
one thing
your
quickly I want to make a comment. Yeah, the rules are not comprehensive enough, right? To and I think immediately these were released after the passage of Finance Act. So some of the basic things which I found missing was that there is no appeal mechanism with respect to if someone questions the chargeability of levy. The appeal mechanism lies only with respect to penalty provisions, right? So
Right.
there is no appeal mechanism. So if the officer says that any, because there are certain exemptions with respect to equalization levy, right? That is any person not doing business or profession is not subject to equalization levy, but there are host of entities, right, which, like, say for example, various NGOs, right, and other persons not doing business but they advertise, right, and so similar, if there is any interpretation issue that what is subject to the levy, right,
Right.
there is no appeal mechanism. So this is
Right.
something very
Sure.
basic which has not been provided.
So
Sure. Sure.
just to add, Sandeep here, just to add that absolutely rightly pointed out, Vinay, that there is absolutely no appeal mechanism whatsoever, except for the fact that if the payer wants to appeal against the penalty only, then he can do that. Otherwise, the payer cannot appeal if
Sure.
there is an increment in the. And the second aspect is that there is no process or no rule. In fact, I would just want to actually backtrack and say that this, not the rules, cannot really empower the appeal process, etc. It should come from the law. So when the representations were made by us, it was mentioned to the CBDT also that there could be a probable way in which appeal mechanism can be introduced, but it was not introduced even when the bill became law. So one wonders whether, how will the payer, if he wants to appeal, what is the process that he will adopt? Is the writ petition the only route available, and will this not only increase the amount of pressure that the high courts and Supreme Courts currently are
Sure.
facing with?
Sure.
And
Sure.
secondly, on the payee side, since it is not yet clear in terms of whether this is a charge on the the whole administrative burden is only on the payer, which is how the law is currently worded,
Sure.
but also on the payee side, there is no appeal mechanism on the payee side. There is no assessment possibility on the payee side, as one can see
Right.
the read the law the way it is drafted today.
Right. Rakesh, India was among the first countries to introduce equalization levy post BEPS. Final BEPS reports were released, but there are few other countries which have taken measures, on their own. Some of them are in line with OECD's suggestions. Some of them have introduced a classic VAT on a B2C transactions. Any global trends that you have seen, and is India or India's version of equalization levy of these global trends?
Right. So I'll answer that question in two parts. Firstly, in terms of what India has instituted as equalization levy, there is no parallel currently that exists as far as equalization levy is concerned. However, there are other countries who implemented. I'm just going to divide that into two parts. Really, one that has been done on the income tax side, and the other one on the indirect tax side of things. I'll just quickly run through the list that I'm holding. For example, UK and Australia have instituted divided profit tax and MAL, as we've come to know in Australia, which essentially seeks to their anti-abuse provisions as trying to tax income which otherwise those jurisdictions believe have been diverted from the legitimate charge of tax in those countries. There is Israel, who's really coming up with the concept of significant digital presence, and regarding that as a PE. There is Italy, who had proposed a withholding tax on e-commerce transaction. We haven't seen that implemented as yet, but certainly there's a proposal on that front. There is Saudi Arabia and Kuwait, who's introduced a concept of virtual service PE, whereby a service PE would arise based on the duration of contract, even where the services are rendered from outside. If I look at the flip side, on the indirect tax perspective, there are some interesting levies, and it makes us wonder where we stand with the equalization levy. But essentially, if you look at Japan or South Korea, for example, South Korea has a 10% VAT, which is not creditable. I think something, Ameya, that you pointed out as well when you reached out to us. Israel has proposed a VAT on B2C services. USA and Argentina, they levy tax on streaming services. So in that sense, I think overall the world is somewhere waking up to the potential of the digital economy, and somewhere they are trying to look at how they can probably collect some tax revenue as part of this the giant enterprise that is facing all of us. and each one is taking their steps in terms of taxing it. I think what is really needed is some sort of a uniformity. Otherwise, it's going to be very, very difficult for businesses to really operate, trying to
Sure.
deal with a unique tax system of each country when we are in such a situation. So I would say that with all that we are seeing globally, there is really a need to have uniformity. Otherwise, the businesses and in turn the growth and proliferation of internet business is going to suffer.
Right. Sandeep, OECD's BEPS project is still ongoing, and there are several deliverables planned in 2016, including one relating to the digital economy as well. Any one or two key areas you think OECD will address in this year so that this risk of double taxation can be avoided in future?
Yeah, so I think that OECD, in fact, discussed and debated 5 different alternatives in the context of the digital ecosystem and how to tax the digital economy. And 2 of them were already recommended by them. One of them being a withholding tax mechanism, and the second being, more to do with the second one being more to do with bringing about a significant economic presence type of a transaction. Um, uh, and the equalization levy, when it was recommended, no, it was not recommended. In fact, the equalization levy was not recommended, which unfortunately the way it was presented in the parliament was that it was recommended by the OECD. So I would think that to answer your question, I would think that from a broader perspective, the OECD must consider how all the countries can unify and bring about one or at best 2 mechanisms in which these kind of taxes can be levied. Because if each country were to start adopting like India has done, and as Rakesh pointed out, there are several other countries, and I also have a list of 36 countries who have adopted different types of taxes around place of supply tax and and maybe digital downloads, etc. But if you look at how the OECD should approach this, I would think that they should consider only 1 or 2 approaches, which should be the only approaches that countries can adopt. And if they are going outside the boundaries of those particular approaches, then they will become very difficult otherwise for global multinational companies, for domestic e-commerce companies and local players in digital ecosystem with higher costs. They
Right.
and credit mechanism. So let's also step back and see how the overall treaty mechanism came into play over the last several decades. And there is already a effective system that is in play, even though all countries are wanting to now renegotiate their treaties for several reasons. But there is already an entire ecosystem around the treaties that is already entered into by several countries around the world. Why not use that as an effective measure to introduce something which is which is to tax the digital ecosystem? Going outside that is trying to create something new, which will take again several decades. By then, several of these companies would have died, and several of these companies would have prospered. But in the entire process, I would think that the consumer, who is the ultimate supposed to be the beneficiary of this whole technological boom, is going to be suffering because of the increased cost by several countries in several different ways.
Right.
So there has to be, therefore, the short point, there has to be a unified way in which all countries should try and tax these kind of transactions. It need not necessarily be only one way. The OECD can look at doing it in 1, 2, or at best 3 methods or methodologies in which this can be taxed in the respective jurisdictions.
Right. Vinay, I will come to you in a minute. I know Rakesh has to leave in a minute's time. So Rakesh, just last question to you, and then
Sure.
you can move out of the call. Is this, we have equalization levy, which is taking care of B2B transactions. And if there is an equalization levy, at least the recipient, there is one certainty that it is not taxable in its hands. But there is still a large volume of transactions which is still outside of the tax net as far as India is concerned, which is B2C transactions. Any comments on how the taxability will work out for B2C transactions, especially in light of this BEPS movement, India's equalization levy. We know we have some judgments in the past from the tribunals wherein some of these taxability has been looked at. Any quick comments, Rakesh?
Sure. So you're right. B2C transactions are currently not within the ambit. It's been defined in a slightly roundabout manner. But let's go with the intent of what Finance Minister said on the House, that B2B transactions are the only ones that would get covered. Now that really leaves us with the whole traditional P ecosystem really that tax office is going to tap into and really apply the more modern rules as they interpret to really determine the tax liability. Equally, the extended rules of withholding are going to apply. Of course, in a B2C transaction, it's going to be difficult to really apply that unless we come up with an intermediary. So given that, I think we are going to land ourselves in a situation where we may see a new list of tax litigation in India centered around the significant digital presence, and that really constituting a sort of permanent establishment in India on more modern principles. Secondly, we are going to see litigation probably around the extended meaning of royalty here, and get into the characterization issues. Both will need to be addressed through a clear set of defined rules, and we are already urging government to really clarify that agenda before we really create another
Right.
major litigation on that front.
Right.
That's what I would say in closing. The other thing, if I'm allowed just 10 seconds more on that, I think one thing that's I really feel needs to happen as part of this rule is the whole discovery mechanism. Today, whoever ultimately bears the tax is not important. What is important is really clarity. If you look at it, payer today does not have any mechanism to discover whether the equalization levy applies on a particular transaction. There has to be a mechanism that defines that, because you may end up in a situation where the equalization levy has been paid by the payer, platform is taxed on a PE basis, and both are going to litigate in their own way, and there is no refund going to ever accrue to them. So I think if I have to say one thing that we need to really make happen in this is to really allow for some sort of a discovery mechanism which will provide clarity on where this levy will apply and how it's going to be implemented.
Right. Right. I
Ameya,
think thank you
thanks
so
a
much,
ton for
Rakesh, for
having
your
me.
insight. Yeah.
Really pleasure. Sandeep,
Sure.
Vinay as well. Thank you guys. Thank you very
Thanks,
much.
Yeah,
Rakesh.
Vinay, 2 points. So OECD's, what should OECD be focusing on in the coming year? Number one and number two, B2C transactions taxability. Any comments on this point, Vinay?
Yeah, so effectively, I think the most important thing that OECD needs to look at definitely is how to prevent unilateral actions by the country which is leading to and will lead to double taxation, right? And because effectively countries taking unilateral action because of some of the conclusions which have not been even been reached by OECD, but being tax being the sovereign right of a state, right? They are free to levy, right? So I think this is the most important thing, that they should, right, come out with a uh, whatever is a legal approach in terms of consensus based, that no unilateral actions are being made. Look, as far as B2C transactions are concerned, if we look at this from a brick and mortar economy or products are concerned, right? So one thing is which is very clear, and which I think there is a clear consensus, is that the majority of changes which are happening, legislation being framed, is in relation to consumption tax, right? Say so today, if you import a CD of a movie, right, a Hollywood movie, today you import it, there could be customs duty, you may pay local VAT before it reaches the end customer, right? But digitally, this is not there, right? If someone downloads, there is no relevant provision. So one thing is, since the consumption is happening in country, right, countries are looking at imposing internationally what is called as VAT, and here GST, right? So that is one effectively legitimate measure, right, which is being, I think, a lot of around 100 countries
Sure.
adopted and signed the OECD right approach paper on the consumption tax on
Right.
digital B2C transactions. As far
Right.
as income tax is concerned, and hence where that why separately, right, tax the way the activities gets performed similar to other industries, right? Similar should be the basis, right, for taxing even B2C transaction in in this. So today, like I keep continuing with my example, if today someone, Indian company imports a movie or a music CDs, right? Transaction happens offshore. There's just imports. Apart from indirect taxes, there's no taxes on the foreign company, right?
Sure.
But with this equalization levy, if this kicks in, it will even be subject to that. So that will make digital incompetitive vis-a-vis other forms of businesses, right? So that I think has to clearly be looked in and not tax that part, and only with respect to what is as a legitimate measure. And hence I think the importance of OECD comes here, that since this all started on account of BEPS measures, right? If the unilateral actions can be prevented, and the common approach, like one of the approaches which is as on date
Sure.
outstanding, is the multilateral agreement. If
Yeah.
countries adapt to it, then there will be a clear security relief, etc., right? Which can be looked at.
Sure. So Vinay will not go into the details of other action plans.
Yeah.
Let me take this to Sandeep. Sandeep, B2C transactions taxability still is a giant elephant in the room, which at least for the moment has been forgotten because of equalization levy. Any thoughts on how litigation and taxability going forward will pan out?
Sorry, your voice was not very clear because it broke off in between. Can you repeat the question, Ameya? It was in
Sure,
relation to
Sandeep.
litigation. Yeah.
B2C transactions, digital B2C transactions, at least for the moment, people seem to have forgotten about it because of equalization levy. How do you think this litigation and the taxability will pan out in the coming years?
So what the government has really done is that under Section 10, subsection 50, they have really given an exemption to the income only subject to the fact that it is subject to equalization levy. Now,
Absolutely.
so if equalization levy is going to be applicable, then the income tax is going to be exempt. So what the government has really done is that it has moved away from a credit-based, mechanism that was available. So hypothetically, suppose there was litigation, and that was a lot of litigation that was currently going on in relation to these e-commerce payments that are going outside India, and the way royalty definition is there, and there is a retrospectivity to it, and whether it overrides the treaty or not. And therefore the whole litigation around withholding tax on that particular payment that was going outside India, on a B2B basis. Now that payment, at least hypothetically, was available as a credit in the foreign country. That was the recourse available to the to the e-commerce players, and to the players in the ecosystem. But with this migration from the credit-based mechanism to a non-credit-based mechanism by introducing the equalization levy, what the government has really done is has increased the overall burden of the cost in India. Also, I would think that
No, Sandeep,
yeah.
sorry to interrupt. My question is on B2C transactions. If I download a song today,
So
by
so
paying
that
$100, so what will be the tax implication on this? Because there is still no clarity on this transaction, and there's a large revenue which is being earned out of B2C transactions by foreign
Sorry.
companies.
Yeah, sorry. I heard it was B2B, so that's the response I gave. So on B2C, currently, as you anyway know, that when individuals are downloading a song and they are making a $1 payment or a $5 payment to a foreign e-commerce website, anyway, withholding tax does not apply on these kind of transactions, because individuals in India are not required to withhold any tax. However, with the introduction of the equalization levy, which is only currently applicable to the B2B transactions, going forward, with the expansion of the possible expansion of other services also coming under the net of equalization levy over a period of time, depending on how the expansion is done and depending on how the levy is introduced, there may still be a possibility that the individuals may not be subject to equalization levy, but the foreign companies who eventually are having or receiving income from India may, through some mechanism in the future, depending on how the government is really looking at it, may in the future want to tax that particular transaction also, even though currently it is not a very substantial number, but depending on how business models change over a period of time, how the digital ecosystem really navigates its journey, which has been a fantastic journey till now, and navigates its journey into the expansion mode, I would think that there will be a taxation element that will eventually come in, given the fact that the government has kept a leeway in the law itself, of introducing similar type of taxes, or similar type of services in the future.
Right. So last question, gentlemen, and Vinay, you can take this first. Equalization levy is just a beginning. Online advertisements, the definition itself is very wide. The report talks about, over a dozen different areas, which, at least the committee suggested. How do you think the future of equalization levy will be in India? Are you worried in terms of its scope, as well as on the rate? And how do you think the future will be? A brief comment first from Vinay and then Sandeep.
Yeah, so definitely there's a lot of concern how the manner in which the levy has been will be implemented, right, has been proposed, right. So on account of there are various issues around it, but I'll cover the most significant. One is especially on account of the rate, right, which is extremely high, right, which will affect right the business operations right of the companies, and if this gets expanded, right, to other services as well, right, then it will be further significant, have an impact on the industry as a whole, right, because this advertising is just one part. There are significant aspects, and this digital industry at present, right, it's currently booming and it's growing, right. So not only right, it affects the businesses of the foreign companies, but there are equally number of Indian companies who are going outbound, right, with respect to who have good platform or digital operations, right, which will affect them as well, right, because such
Sure.
kind of actions will also be taken, right, could be taken by other companies, right. And more
Sure.
importantly, one more significant concern which is there from industry perspective is, right, then on the manner of implementation of the levy, that while it provides that there's a 6% gross withholding which is exempt from income tax, but this levy is not applicable when there is a permanent establishment, right. So effectively, what prevents a tax officer, right, while equalization levy is being paid, right, will still continue with the P mischief, right, and
Sure.
there is no refund mechanism. So that's so the concern is most on the double taxation and high taxation surrounding digital, which will make it could make it incompetitive, right, vis-a-vis other forms of, because this is not there for other right, say forms of advertisement, right, or other industries.
Right. Sandeep, quick 20-second closing comments.
So let's step back and also look at how the Modi government has, very well also, initiated the Digital India campaign and the Startup India campaign, so as to promote and encourage the players in that ecosystem to do more, because that's where the growth is really coming in from, and the disruption and the innovation is coming in from, and that is what is the need of the hour today. With that in the backdrop, and as we've been discussing for the last 45 minutes, that we are talking about 6% levy being introduced. The cost is eventually going to be borne by the way it looks like, is going to be borne by the consumer in India, and which is also going to be the B2B small player who is going to be sitting in India. With that, I would think that the government should have considered, like they have very well considered in the recent past. They've come up with consultation process on various issues, which is such a welcome move from the government side. It would have been great if there was a consultation process also introduced in this context, so that the ecosystem players, whether it is a small startup ecosystem players or the larger e-commerce players, could have provided perspectives around how this is going to be impacting the business side, how the sector is going to get impacted eventually. But since that was not adopted, at least going forward, this is a strong recommendation that I would like to make, that going forward, when newer services are likely to be introduced, there are 12 or 13 that have already been identified and is there in the equalization report. When two things: one is when newer services are likely to be introduced, or the rate is going to be increased from 6% to 8% or 10%, as is already mentioned in the equalization report about 48%. I would recommend that the government considers strongly taking inputs from the ecosystem players, because just introducing a wider set of 13 services or whatever number of services that are going to be introduced in the future is going to create more uncertainty, going to create higher costs in the ecosystem, going to create more different channels for consumers to adopt going forward, because that will only encourage consumers to ultimately look at whether it is a B2B consumer or a B2C consumer, to adopt or to look out for different means and mechanisms to find to reach their own set of consumers and grow their business. So
Right.
this would be a strong recommendation from my side.
Right. Thank you so much, Sandeep, Vinay, for sparing your time and joining this special Google Hangout on June 1st. And let us see if this equalization levy creates a more balanced and equal tax system. Thank you so much once again for your time. Thank you.
Thanks, Ameya. Thanks, Vinay. Thanks. Bye bye.